I call the Honourable John Boscawen.
Thank you, Mr Chair. The ACT Party strongly opposes this piece of legislation, Mr Chair, in the same way that the ACT Party opposed the Foreshore and Seabed Act 2004. In fact, the ACT Party is the only party that has had a consistent policy, a policy based entirely on principle in its opposition to the provisions of this bill, Mr Speaker. Mr Speaker, the ACT Party over the next 2 or 3 days with your support will have an opportunity to put our arguments out into the public domain and to repeat those arguments, sir, because they are powerful arguments. They're arguments that have been ignored by the government, Mr Speaker, and they're arguments that need to be understood by all New Zealanders. But, sir, let me just comment very briefly on the speech of the Leader of the Opposition when he was commenting on the preamble, Mr Speaker. He said that the Prime Minister promised that this bill would not proceed unless it had widespread support. And we know, sir, in this House today, sir, that this bill does not have widespread support. The fact that it has widespread support, Mr Speaker, or the suggestion it is an absolute fiction. So the preamble sets out the history of this bill and how we got to this stage. And as the Honourable Attorney General, Christopher Finlayson, points out, that it started, Mr Speaker, with the decision in Ngāti Apa in 2003. And so that name, Ngāti Apa, is banded around the House. Most of the members in this House would know some of the background, but probably few members of the New Zealand public would, sir. We had in, sir, Ngāti Apa decision, we had 9 iwi from the upper South Island. I'm told it's 8. I'm happy to be corrected on points of fact, Mr Speaker, but it was more than just 1 iwi, sir. It was more than just the Ngāti Apa iwi. There were 8, sir. And they 8, sir, brought a case asking for recognition of what they said their customary rights were to parts of the seabed of the Marlborough Sounds. And Ngāti Apa was just one of those iwi, just one of those 8 iwi, sir. And if you like, sir, they've lent their name to this case, which is now etched in the memories and the history of the debate over this bill, sir. And so they brought a case and it went all the way to the appeal court. And the appeal court accepted their claim to the extent that they were seeking to have their case heard in the Maori Land Court. And that was had previously been denied to them, sir. The right to bring that claim had been denied to them in the High Court. High Court acting on a decision in the appeal court in 1963, the decision of 90 Mile Beach. And so it was expected, sir, that the appeal court, when it heard this decision or heard this case in 2002, would follow the decision in 1963. But it didn't. To the surprise of all, and I suspect including the leader and the deputy leader of the government at the time, the Prime Minister, the appeal court decided that Ngāti Apa and the other 7 iwi were entitled to go to court, sir. And it's very important to understand what the court decided, sir, and what it didn't decide. And that is the crux of this issue. The court did not decide that Ngāti Apa and those other 7 iwi had customary title to the seabed and foreshore. It didn't say that. There was a widespread misrepresentation, misunderstanding of that decision, Mr Chair, but it didn't say that. What the appeal court said, sir, was that Ngāti Apa had the right to go to court. The right to go to court. And so that is a right that the ACT Party has consistently spoken up for and defended ever since the decision was brought down by Justice Shana Elias and her 4 colleagues in 2003. Sir, the right to go to court. And so, sir, when the Labour government announced within 36 hours of that decision that it was going to pass legislation to take away that right, sir, or certainly to severely restrict it, the ACT Party opposed that. We know the background. We know that Tariana Turia gave up her ministerial position in the Labour government, stood in a by-election, sir, and formed the Maori Party. But, sir, it is important to understand that what that decision said, sir, is that iwi have the right to go to court, and nothing more, sir. In fact, if it did say anything more, what the judges said is it is a very, very high test. A very, very high test, sir, to actually be awarded customary title. But carrying on, sir, to the next clause of the preamble, clause 2, it talks about the bitterness, the difficulty that the decision, that the passing of that legislation in 2003 created. And as a consequence, sir, when the National Party was elected into government, it formed a confidence and supply agreement with the Maori Party, and there was a commitment. Mr. Chair.
Honourable John Boscawen.
The National Government agreed with the Maori Party to review, sir, the Foreshore and Seabed Act. And, sir, as the Attorney says, and as is laid out in paragraph 3 of the preamble, that ministerial review panel, sir, recommended that the Act should be scrapped and replaced. And following that, sir, we have this document here that was produced by the Office of the Honourable Christopher Finlayson. It's called Reviewing the Foreshore and Seabed Act. It's a very concise document. I would actually recommend, Mr. Speaker, anyone who has followed this issue to actually read what this document says. I'm sure it can be downloaded from the internet. I presume it can, sir. But the interesting thing, sir, about this submission is that the Attorney-General announced his decision to call this review, to publish this review, the week before Easter. The week before Easter 2009, and he announced that he was closing submissions on the 30th of April. 30th of April. 4 weeks, Mr. Speaker, 4 weeks, Mr. Speaker, for the people of New Zealand to digest this document, to understand the history and make their submission, sir. And what we now know, sir, is there's 1,500 people or 1,500 organisations, sir, made a submission on this document. And I say we now know that, sir. We didn't know that in May. We didn't know that in June of last year, Mr. Chair. We didn't even know it in July or August. Because when the Attorney-General was asked to release, sir, the submissions that were made on this document, he refused to do so. He continually refused to do so. And it wasn't until an Official Information Act was lodged that he actually reluctantly released those submissions, sir, late last year. And what do we know, sir, Mr. Chair? We know that 90% of the people who made submissions, sir, on this document opposed what the government was proposing. The government set out 4 options, and it was very clear, reading this document, Mr. Chair, that option 4, the government's proposed option, was opposed by 90%, sir, of submitters. So we now come, sir, to the bill. And clause 3 of the preamble refers to the bill. The process, sir, of this bill passing through this Parliament has been an absolute disgrace. An absolute disgrace, sir. I sat as a member of the Maori Affairs Select Committee, which travelled around New Zealand hearing submissions on this bill, and I was supported by my colleague Hilary Calvert. Mr. Chair, the Maori Affairs Select Committee heard submissions on this bill in Whangarei, in Auckland, in Tauranga, in Wellington, and Blenheim, and in Christchurch. And sir, I'm actually very happy. Sir, to respond to the taunts of Mr. Tau Hanari, because he was the chair of this committee, and clearly he's got a very bad memory. Because I attended the sittings, sir, in Whangarei, I attended the sittings in Auckland, in Wellington, and in Blenheim. Hilary Calvert also attended the hearings, sir, in Tauranga, in Christchurch, and in Auckland. So the ACT Party was represented. We listened to the people, and I can say on behalf of my colleague Hilary and Calvert, who will be speaking, sir, on the preamble later in this debate, sir, with your support, with your giving her the call, sir, we were shocked. We were absolutely shocked at the way that some of the submitters were treated by the Select Committee, sir. They were treated discourteously, sir. People of New Zealand, they come along, they get involved in the parliamentary process, they make a submission, sir, and they don't come along, sir, expecting to be abused, to be spoken down to, and to be called liars, Mr. Speaker. Mr. Chair, rather. Mr. Chair. So what came out of that Select Committee, sir? 4,500 submissions, or was it 5,000 submissions? What we do know is we know that the overwhelming number, sir, of submissions on the bill were strongly opposed to the bill, sir. And now we come, sir, to the farce, the absolute farce with which the members of the Select Committee considered those 4,500 submissions. And they met together on the first afternoon that the Parliament set this year, and they considered a 520-page report, Mr. Chair. 520 pages, and they considered it in less than 2 hours. And so they wrote a report the following day the report of the majority, one page, summarising this issue in one page. And attached to that, sir, was 40 pages of objections. So 40 pages of recommended changes. Mr Chair.
Mr Chair.
Thank you, Mr.